Matter Brianna and Salcido versus Sean R. Majeski, 2016-5918 PS. Continued motion in this matter. Parties are present, and actually, Staker.
Staker now, yes.
Thank you. I apologize for that.
That's okay.
Staker is in the courtroom represented by Attorney Brian H. Jean. Mr. Majeski appears in pro se. Court reviewed the pleadings again. There's been an amendment to the plaintiff's motion. That court has reviewed that. Court has also had the opportunity yesterday to meet the minor child in question. And again, we don't refer to the child by name. But I have a smile on my face. You have a very bright young man. I was very impressed with this young man. He was able to communicate clearly. He spoke. He was not afraid to speak. It was good. It was really good. I was with Ms. Schultz, so court has had that opportunity. So I want to thank both parents for, at this point, what it appears to me to be a heck of a good raising of a young man, because he spoke well. He looked at you when he spoke. He's going to do well. He's going to do well. But if the court's considered that, Mr. Jean, do you have any further proofs you wish to present regarding this?
Your Honor, I think we left off, there was a cross-examination that was continuing of my client. So I don't know if the court wants to continue from that point.
We can do so if you wish.
Yes.
Please return to the witness stand, and we'll place you back at your oath. Please raise your hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Mr. Jean, you may continue.
Your Honor, I think we left off as
Mr. Majeski, that's right. You're right. Majeski, you may continue with your question.
First, the last time we were here, you brought up the ER visit and you stated to the court, I did not inform you till the following night after the visit. Is that correct?
Told me, yeah, it's the next day.
When we were in court last time, you said the following night.
You never told me that, no.
No, the following night after the ER visit.
Yeah. Yeah.
Okay, well, in the ACLOS app that we, of course, I went back and looked. The following morning,
objection.
it was at 9.
Your question first.
Okay, well, she's saying because of communication issues, she said the following night. I didn't let her know.
Okay, you can ask her regarding what happened, but you have to rephrase your question.
Okay, well, I was just asking why would you say it was the following night when I went back and looked in the ACLOS app and it's at 9:53 a.m. on September 20th, 2003. So it was the following morning.
It could have been, yeah, but it was the following day, for sure.
Yes, and that was because we did not have our phones at the yard. I told you that. So,
Objection.
These are your question.
well, why would that be an issue to you if I let you the following morning? You did not get back until after 10 o'clock. That was too late.
My issue with that is you had told me that it was not anything that you were worried about. It was not anything important. Then as I started asking the questions, he had told me that they follow up with notes. I questioned you, and you had said, oh, well, the nurses were worried that because he was so sick. You should have notified me, regardless.
Did as soon as the next morning.
Objection.
You could testify to that if you wish. You have to ask the question.
Okay. How else would you, with us not having their phones in the ER, how else, besides letting them know late at night, all in the morning, how else?
Objection, what was that?
What would you rather have me do? Ask or contact you late at night or first thing in the morning?
Late at night.
And at that point, would it have made a difference? Because you're already.
Yes, it would have. To me, it would.
Figured late at night would be too late, so early in the morning would be the best choice.
I want to know when something is wrong with my child.
And since then, you have also taken the Apple app you have told me, which you did not tell me till the following day. So why would that be okay? And what I did was not.
I check up on Steve every time you tell me he's sick. He's got fever. You take home from school. I check on him multiple times. You go to the ER, I'll tell you. You take home from school, I tell you. Never do you ask how he's doing after that. You just say, okay.
But you did tell me the following day, same as I did. So what would be the difference between me telling you the following morning and you telling me the following day?
Because I care what happens with my child. I check up on my child. Communication with me and you is not there. I can tell you that Hampton woke up last night and he wasn't feeling good. I can tell you that, and you don't call check up on him. So me, I do tell you when I know. You don't answer me. If I would have texted you in the middle of the night, you won't answer me. You won't wake up. I hear my phone. But yes, I want to know what happened, and I have told you that multiple times.
But once again, if me telling you the following day is not okay.
Objection, has an answer.
Nope, I really got an answer to the question.
Why is it okay for you to tell me?
So for me, I wake up in the middle of the night. I do. I want to know what is going on with my child if he is in the ER. And for you to tell me that it wasn't anything serious, and then come to find out it was serious, that's a lie. You just lied to me.
Did I say it was not serious?
Yes, you did.
Because I stated when I sent the message that we rushed him there, not even bring her phone because he had 104 temps. That's how serious it was.
You told me after I had questioned you.
I told you that before.
You told me at first that it wasn't anything that we were concerned about. And then after I had questioned you about it because they see the COVID test, I asked you, and then you said, well, the nurses were concerned because of his temperature.
You did have 104 temps, and yes, they do take a flu and COVID test to make sure. So they were concerned and tested negative for both. So after we left, it was not a big concern. They said just make sure his temp drops after they gave him the medicine, which it did. I stayed up with him that night to make sure it's low.
Objection, Mr. Majeski, what's your question?
Just my main question is, why is it okay, or what is wrong with me informing you the next morning after I woke up?
I just want to know when he got out of the hospital. I want to know for me.
Okay. And then my next point would be how you said we have been treating Steve as an adult, not a child. You stated that us saying your house is not a mansion, just a big house, is considered treating Steve as an adult. Right. Okay, so if that's your standard for us treating him as an adult, I have some examples I would like to ask you. personally, I have no issues with any of these things going on that have happened. But if your standard, if you're setting the bar here for one thing I have said, I have to ask why what you have done will be any better or worse. A couple months ago, he came over around Halloween time, and he came in and bragging on how he got to watch.
Objection. Your side.
Staying. He's be a little more specific and then focus on what the child is saying.
You allowed C to watch Scream, which is a rated R movie. That is okay, and I'm treating him as a kid, which probably shouldn't be watching a rated R movie. Why is that any worse or the same as saying you're not rated R?
Objection, Foundation. Black Foundation.
Staying.
Over Thanksgiving, I found a video and see the iPad. Just playing. He had our Thanksgiving over at my parents, and he was playing with his friends. He made a video, and then in the video, dropped the iPad. Said, "Oh, that's HIT," swore.
Objection, hearsay, and Black Foundation.
Staying, but what's your question?
When I asked him about swearing, because he hears his mom swear.
Objection.
Can you go over child is saying?
Okay, well, I have also witnessed a handful of times we have around back to you. Once again, I don't have a problem with it, but you have said, "Oh, he's a little SHIT, he's so thinking cute, he's a cute little SHIT," multiple times.
Objection.
I have
Second question.
Yeah, well, I have witnessed her saying that, so I mean, why is it okay that you swear and he is now swearing?
Objection, Foundation.
Mr. Majeski, there's been no foundation that mother is swearing in front of children. That's not been established at this point. If you wish to establish it, go ahead, but I've not heard of that.
Okay, well, when I have taken Camden back to,
Please refer to the initials.
when I have taken C home before, she has sworn in front of us.
You're testifying. You can ask her whether she's done that.
Okay. Have you sworn, not, anything bad, but just saying he is a cute little SHIT?
I think we all do that.
Yeah.
as parents.
I believe that's okay, correct?
Yeah, absolutely.
So if he's learning that from you, would you say that is not being a kid and more as an adult because he's wearing as a 6, 7?
Objection, Black Foundation. There's been no testimony of child swearing.
Suspended. You can ask whether the chief of the did.
Have you witnessed him swearing?
I've never witnessed swearing in our house with Steve. He does not swear.
Okay. So if I show you the video and you've seen it, and nothing bad, but because you just said you have sworn in front of him, would you not say that is treating him more as an adult than treating him as a child? If your standard is us saying your house is not a mansion, why would swearing be different?
I have more of just that. Why I feel you guys are treating him as an adult. I have more. Those are just the only two that kind of came out.
Okay, and if you do have more, well, what were those?
Okay. So your significant other used to work at the school, correct?
Yeah.
Okay. She was around him a lot, correct?
Now, wait a second. You're the witness, you're not questioning.
I know.
Questioner.
I know. Okay, this is the big one. He had come home and he was playing with my husband. upstairs. They were doing something. I don't remember what they were doing. They were playing with his daughter as well, with our daughter. And he had kind of flipped about a little boy.
Okay, now we're getting into hearsay again. What's good for the goose, for the gander.
Right.
So the court, sua sponte, is cautioning you not to make any statements that are hearsay relative to the child. Okay, would you ask a question?
Okay.
Or if you want to answer the question, the one that was posed, go ahead. You can't promote child marriage.
Being told what another happens to being told what happens in school should not come home to my child. And that's all I'm gonna say.
This child, which had also been to our house before, is a foster child that was just adopted. The teacher has told the whole Santa Foundation, explaining already what has happened. So there's no difference from re-explaining what has happened than what the teacher has already explained.
Objection, foundation. I'm really interested in what you're going to.
I'm trying to understand why she thinks any of this is inappropriate, because
It's what's inappropriate.
that we had a foster child at our house and we explained to see that he has been through trauma and he acts a certain way because of what happened. But the teacher also explained that he cusses and swears a lot.
The foster child.
Yes. And we babysat him all summer last year because Miss Ritter was his parapro at the school, provided transportation to him from school, and she watched him last summer.
Okay, but what does that have to do with this motion?
She's saying that because of us explaining why he may swear, why he may act a certain way wasn't inappropriate, I wanted to find out from her why this is an inappropriate action.
So that's your question.
Yes.
So, okay. So what you're saying is the teacher that told all the kids what was going on,
The whole class.
even the abusive parts, about him being thrown over a fence. She's told him.
Stop. We are, this is going well beyond the pale here. It's a question and answer. You simply answer the question that's posed, and you're not questioning the question. You can flip the rules and switch, but you have an attorney to address that. So I just need an answer.
It was the abuse that the little boy went through.
Okay. Go on with your next question.
Okay. Okay, referring back to when you said Camden threw up in his bed. C. Sorry. When C threw up in his bed, I was too scared to, which he did come down and said he wasn't scared and explained to him.
Okay, don't elaborate, just ask the question.
So, he was scared. He told him it was fine. If we go back, I won't say, but for Send Foundation, when you go back to the day he called to tell me you were pregnant. It's relevant.
Stay. We have to go back to the last custody order that has been entered into this case, and that's well before it.
All right. At this time, no more
Question.
Read it.
Here. I just want to briefly clarify a few issues, ma'am. You were asked a couple questions about your concerns that you have regarding the minor child and some of the things that are happening at Mr. Majeski's house. Could you tell me or clarify what your concerns are? I don't want to know who said what. I want to know what your concerns are.
My concerns are that I feel as if he is not being treated properly. I feel as they are treating him older than what he is.
How
I
so?
feel he cannot be a child over there.
How so?
Just the conversations that his significant other has with Steve.
Have you witnessed those conversations?
I've not witnessed them personally.
So you're just you're getting this from somebody else. This is a concern that you have.
Right.
Okay. So you can't tell the court what the conversations are. True?
Right.
Okay. But you have concerns over the contents of the conversations?
Yes. Yep.
Okay. And do you believe that there's some issue that is arising from these conversations that's affecting the child?
Yes.
How so?
When we get him back, his whole, he's just kind of off. He's off, and it takes him a while to.
Let me stop you there for a moment. Could you describe to the court your minor child's normal demeanor? How would it be normal?
Happy. He is crazy 7-year-old.
Okay. What do you mean by that?
Hyper. Love.
Does he talk to you? Does he give us a little bit more detail?
He used to talk to me. He used to, but now he doesn't. Just I'm fine. Nothing's wrong. I'm fine.
Okay. You testified a moment ago when he comes back from Mr. Majeski's house that he's off.
Mm-hmm.
Could you please describe what you mean by that?
He's not as. I feel as if he's worried about if I'm going to sit him down and have a conversation with him about what goes on over at his dad.
Do you do that?
I'm sorry.
Do you do that?
I used to sit him down and ask him if how did it go? Did you have a good time? Is there anything you want to talk about? But I don't do that anymore.
Okay.
I don't feel as if I need to throw my child when he comes home. I feel as if he wants to tell me something, I let him know that he can always tell me anything.
Please continue with what it is that you feel is off.
He's just not. We have 2 other kids. I have an older son, and I have a stepdaughter. It takes him a minute to really enjoy himself, I guess. Enjoy being home. It takes him a minute to realize that where he's at.
When you say a minute, how long are you talking? An actual minute?
No, it'll take probably 10, 15, sometimes 20 minutes before he is acting himself again. Running around, playing video games.
So I want to stop there for a moment. Has that been a new behavior?
It's been pretty, maybe since the last time we've come to court, it has been.
The behavior you just described has been recurring?
Yeah.
Okay. Have you had any conversations with Mr. Majeski about that?
I have tried to talk to Sean, but our communication is not good. It's not good at all.
What do you mean when you say it's not good?
I did, for instance, if I did tell him that he was sick, he would say, okay, and that's the end of it. The counseling, for instance, I have talked to him a couple times about it, and he asked what was going on, and I kind of explained to him. But again, it ended there. There was nothing after that. No yes, no, I'll think about it. Just
So you've been unable to establish any sort of solution for these issues with Mr. Majeski?
yeah.
You were asked a series of questions regarding an alleged incident that you did not inform Mr. Majeski about an ER visit. You recall that questioning? Okay. So, first of all, is there a time at all that you can recall that you failed to inform him of a medical appointment or an ER visit?
No.
Okay. In your mind, what is an appropriate amount of time that would go by before you would inform Mr. Majeski about an ER visit?
I personally, I want to know when you're going. I want to know when you're there. I do recall now the reason that I had told Sean about it in the morning was because we didn't get home until like 4 or 5 o'clock.
What time did you go in?
We went in, he was complaining about it all night, couldn't go to sleep.
Okay, I understand. What time did you
It
go in?
was about 1 or 2.
In the morning?
Mm-hmm.
Okay. And you were released at 5 a.m.?
Mm-hmm.
Is that a yes?
Yeah, sorry. Yeah.
And you informed Mr. Majeski when?
Probably an hour or 2 later.
Do you feel there's a difference? Do you feel there's a difference between a 9 p.m. visit and a 1 a.m. visit in terms of informing the other parent?
I do, but that's me.
Okay. Well, I mean, let me put the shoe on the other foot here. You take him in at 1 a.m. Do you want to know at 1 a.m.?
Yeah.
You didn't inform him at 1 a.m.
No, I did not.
All right. But you did tell him that happened, that you took him in, correct?
I'm trying to think if I did.
Let's do this before we go any further. Do you ever recall when this was?
I don't recall when it was. It was.
Was it more than a year ago?
No, it wasn't a year ago. It was maybe 5 months ago.
Okay.
It wasn't too long ago.
All right. Do you believe that it is Mr. Majeski that is causing the problems in his home that you are concerned about?
Yeah.
Why do you believe that?
Because I had stressed my concerns with Mr. Majeski, and he doesn't have
You said stress here. Oh.
and he doesn't want to.
What do you mean he doesn't want to listen?
I would tell her my concerns when it comes to see. We have thought conversations with my brother, and I feel as though he ignores them.
How often does that happen?
Well, I used to tell him when it happened, but I don't anymore because I did, you know, insurance.
Okay. Thank you. Nothing else.
Miss, I just wanted to go back to December 22nd, when we began the hearing. I thought it was December 2nd, but the issues regarding counseling, what are you requesting regarding counseling?
I want, he was very humble with you. Thank you for that. I want him to be able to open up to somebody. If he can't open up to me, or if he doesn't want to open up to somebody. I want him to know that it's okay that you're scared. I guess I just want to know what's going on.
What do you propose regarding this? What do you want?
I guess to know that he's okay.
Have you ever expressed these concerns at the school with the school council?
No, I have gone to talk with the principal about my concerns.
But there is a school counselor. But you've never reached out to that individual.
No.
Have you been directed to go to the school counselor?
No.
Any questions in light of the courts?
No, Your Honor.
Sir, any questions in light of the court's questions?
No, Your Honor.
Your next one, Ms. Majeski.
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Yes.
Gene, you may proceed.
Sir, can you please state your name for the record?
Sean Majeski.
Could you please spell it for us?
BANMAJ.
Thank you, sir. Just a couple ground rules, please, just do remember, as when you're referring to the minor child, please don't use his name. I know, it tends to slip up, that's okay, but it is important that we don't do that, so it's not broadcast all over the internet. Second thing is, if you don't understand a question of mine, please let me know. Don't answer something if you're confused about the question at all. And lastly, please make sure that all of your responses are verbal, because everything is being recorded, so a head nod doesn't translate into a recorder. All right, thank you. Sir, you are the father of the minor child at issue in this case, is that correct?
Yes.
And sir, you share joint legal and joint physical custody of that minor child with my client, is that correct?
Yes.
And sir, you had an opportunity to review the motion that's been filed on my client's behalf, is that correct? And you've indicated at least implication in your cross-examination that it is true that my client has attempted to have conversations with you regarding counseling with a minor child, correct?
Correct.
And you are opposed to the minor child being in counseling, is that correct?
Correct. There's no real issues that I see are that he either can't talk to a parent or also encounter the school counselor that is very close to the school that he can talk to.
How many times has your child spoken to the school counselor?
He, on probably a daily basis, at the school Monday, Wednesday, and Friday, and we're out quite a bit. I don't know if he talks about any issues, but he's very open to them, very comfortable with them.
Any witnesses?
Yes, sir.
Yes.
You've witnessed it personally?
I do not.
Okay, so the answer is no then. Let me ask this. You indicated that you don't believe there's any issues at your house that the child would need counseling for. What if there's issues at my client's house?
more than welcome. I never said you can't go to counsel.
You share joint legal custody, sir. You understand that?
Yes.
You understand that if you have a request that the child has medical treatment of some sort, the two of you need to agree. You understand that?
Okay, yes.
And if you don't agree, my client can't enroll the child in counseling. You understand that?
Yes.
Okay? But you're saying today that you wouldn't care if she enrolled him in counseling.
If there was legitimate reasons, if he was misbehaving. I don't believe if there's not a good enough reason to go counseling, and there is free counseling at the school, why should he have to put a child in that position if he doesn't? If he does need it, and there's evidence that he needs it, then I'm all for it.
Okay, let me back up for a moment. Do you have some sort of apprehension about counseling in general?
My oldest son has went to counseling. It had more of a negative effect on him.
I see. Don't you believe, sir, that if there is no issue going on with your child and he is in counseling, that would come out and he would be cleared by the counselor?
It might, or as with my oldest child, it might make him think that something's wrong.
Are you concerned with the cost of counseling?
No, but if it's not warranted, then I don't believe he should have to pay for something that he doesn't. But if he doesn't need it, like I said, I'm all for it.
You heard my client's testimony that she's tried to discuss this issue with you, right?
A couple times, yeah.
Okay, and you heard her testify that you've not discussed this with her, that you summarily rejected it.
I did not reject it. There was.
Are you suggesting that my client didn't tell you what the issues were?
I heard what the issues were, but that is the end of the conversation. There's no more push forward, back that. There's no more, I think, this, shouldn't do this.
So you asked her a question to clarify what the concerns were. She answered that question.
Yeah.
And you still didn't agree.
The end of it, there's no more, well, can we talk about it? You know, keep talking about it. There's something we can work out. There's no more conversation about this now.
So you said that this happened more than once.
Yeah.
So you're suggesting that that's how the conversation went for every time that you spoke about it?
It was brought up the first time. What the issues were, she clarified it. There's no more. Please do this.
Well, what do you expect her to do when you deny the opportunity for the child to go to counseling?
I said I didn't think what she provided, he needed it, but she also didn't push back either, saying, I think he doesn't. I think, you know, if it was serious as a parent, I think you would push for something that you truly believe in. There was no push there towards that. It was the end of the conversation.
So your position is that because she didn't press the issue further after you said no, that it's not a big deal or he doesn't need it?
On my end, I don't think he needs this. Like she said, he is a happy-go-lucky kid. Right. Always no signs of anxiety, any depression, any, you know, anything that would deem he needs to go down.
I see. Don't you think that if my client sees some sort of issue that's going on at her house, she wants to have counseling, that maybe there is something going on at her house and counseling would discover that?
If there is, and she brings it up to me, which she didn't,
if you had a concern about your child medically, you could take a good example, like a vaccine, right? You believe that, for example, your child shouldn't have a vaccine, and my client believes he should have a vaccine, right? To what extent do you think that you should discuss that issue?
Well, I think as adults, stop it.
You haven't done that here, though. You simply told her no, right?
At the point of what you provided, yes. I believe as a parent, you can sit down and talk to your child, and then go from there.
Okay. My client testified that it's difficult to communicate. Do you agree with that?
Yes, there's many reasons why.
Okay. And I believe that you had indicated previously, when we were here, that in fact you have discussed court matters with the child. Is that true?
As far as what?
That he knows about court matters.
I don't think so. Right.
I'm asking you.
No.
So your answer is you haven't done that? Okay. Has your significant other spoken to the child that you observed about court issues? Okay. Do you deny that you spoken poorly about my client in front of the minor child?
We do not speak, and it's very clear. Never spoke to speak badly, or really bring their names up, ever in our house.
You recall when we were here last in court, not for this motion, but last year, and you recall there being discussions about the conversations and the things that your significant other was saying.
I remember being brought up, but there's no specific conversation. What was that? Yes, I do recall.
Right? And you recall that you were told by the court, these things aren't going to be happening. You can't have these sorts of things going on in your house. You recall that?
They weren't going on, but I do recall.
So is it your opinion that my client is simply just making these things up that she has concerns over?
Some of the stuff, yes.
Okay. If you believe that that's true, and she's just simply making things up, why haven't you filed a motion with the court to address that issue?
A lot of the stuff is pretty petty, but I would say call multiple times trying to get her in trouble or fired from jobs, saying she has been fired for child abuse. That was completely made up. I mean, there's multiple things. So because of that stuff, that is why there is some lack of communication, because it's been going on for years. Like, there's a time when Miss Ritter worked at school, and
So, sir, I'm going to stop you because that's not what I'm asking you. What I'm asking you is, if you believe that she has made things up, you believe that she's just causing these problems, why have you never filed a motion to come before the court to say, Judge, tell her to stop doing that?
well, I was in court 2 years ago with my oldest kid. There's way more bigger things, drug overdoses, things going on in the court that I did file a motion for. Not many things were changed. This is pretty small compared to what I went through with my oldest kid. So I don't see a point in filing a motion when something way bigger has already happened and I have to do the situation before my oldest kid.
you don't think that it would be important or significant enough if my client is making things up about your child?
Not about my child, but about my girlfriend.
Well, isn't that really related to your child? Because if she's claiming that it's your girlfriend, that would affect your child, would it not?
Yes. And she has seeked an attorney and has talked to him about the phone calls, child abuse stuff that has been brought up. Because she does work at a school, it does work for her, she did. It does, have a bad reflection on her. There's nothing being said about it.
So ultimately, you don't have a reason as to why you come to the court.
I didn't come to the court.
Well, you're right, you didn't. I'm asking, you don't have a reason as to why you didn't.
No, because he did.
Okay. I have nothing further.
Would you present any other testimonies?
And so I guess, like I said, over the past few years, Stagger has called multiple times on this Ritter, tried to get her in trouble, getting her fired. That is one of the reasons.
I'm going to object to lack of foundation.
Allow me to testify to court.
They made up saying she was fired for child abuse, which she wasn't. Why make this up? It's very hard to co-parent with someone that is coming after you for small stuff like this. Stuff that should be able to be handled. But when every little thing is an issue, it's hard to color them and then make sure, like, see, we're trying to help Camden. See. And then it becomes an issue instead of helping them. A few years ago at school, when Miss Ritter worked there, we presented something and supposed to be no disclosure. She's not supposed to bring stuff out, but was having some issues. They were fighting at the playground. We brought it up. She called the principal. She got wrote up. We were simply just trying to help see something, better, not to be fighting kids on the playground. But she turned it around and brought it on Miss Ritter when they're simply just trying to help. So because of issues like that, the last time we were in court, Miss Ritter already took the job as a front grade counselor. That day after court, there was a phone call to Officer Rowe saying Miss Ritter had court.
Objection here, sir.
Okay. Just because of all these issues, because they are nitpicking and digging at stuff, it makes it very hard to cope, and it does make it hard to communicate. Because if I do tell her something, because they don't come back or not, that's my favorite. And as far as Camden, I don't see, as far as I don't see any issues. I think it's perfectly awesome. Good. All it's this year they're a lot better this year, improvement from the previous year. Teacher had everything had to say, and what she said. And as far as anything inappropriate, Ms. Ritter and I are both mandated by the state to report because I'm a referee for the serving at school. We have to report any child. Ms. Ritter has recently just reported child abuse in our neighborhood and had CPS. They have to remove a person now. She does care about the children too. So these allegations are embarrassing for her. She's her family constantly. Yes, it does make it very hard to co-parent.
Any redirect?
No.
to present any other proofs other than what you testified to, Mr. Majeski? In other words, do you have any other ones?
I do have some letters of recommendations for Ms. Ritter, just stating how good she works with kids at the school. I don't know if you would take those. Consider those.
Well, the issue here is legal and physical custody, so the court will not argue.
Thank you, Your Honor. As the court is aware, Majeski versus Majeski, 336 Mich. App 639/2021 establishes that a modification of legal custody utilizes the same framework as Varka for determination of modification of legal custody. We believe that we have established by preponderance of the evidence that there is enough here for a review of, at minimum, the legal custody of the minor child, given the fact that the parties are unable to agree on significant issues, primarily being counseling for the minor child. I think that rises to a level of preponderance of the evidence here. And I think that needs to be reviewed. What I find interesting about the testimony regarding the counseling is Mr. Majeski simply tells the court, well, I just don't think that it's necessary to go to counseling, but can't really answer the question about counseling having some sort of real negative effect, other than I believe it had a negative effect on another child. Fact of the matter is this, that if nothing is going on in his home, nothing is a problem, there shouldn't be a problem to send the child to counseling. Child is perfectly fine. The parties are going to get very quickly a recommendation from the counselor. There is no issue here. There is no concern. But yet, he doesn't want to do that. Even when he's being asked questions about the discussion surrounding this, he's dancing around the real answer here, the real core of the issue. He says, well, just kind of stopped at that. She didn't really press the issue. What is she supposed to do? She knows she has joint legal custody. She asked him. He says no. He testified as much. I asked her why. She gave me the reasons, and I said no. That's really what happened here. To suggest now that, well, she should have pushed that more. She should have said something more about it. To do what? To somehow change his mind? He's already said that, and here we are. That's the appropriate thing to do. I also find it very interesting that he suggests that all of these issues are problematic on my client's end, but has never filed a motion to address those issues, and simply says, well, what's the point? I think when the court looks at all of those things, certainly the preponderance of the evidence standard has been met for the determination that there has been proper cause pursuant to Majeski versus Majeski. We are asking the court to refer the matter to the front of the court for a determination and recommendation as it relates to custody. In the meantime, pardon?
Legal.
Yes, Your Honor. As it relates to the counseling, we would ask the court to issue an order that the child can be enrolled in counseling. I think if we were to do that now, if Mr. Majeski were right and there were no issue, that could potentially be resolved before we even went to the front of the court. So I am asking the court to make those considerations today.
Thank you. Mr. Majeski, your final argument, sir.
Okay, I would.
Please stand and be addressed. Now you're arguing. Okay. You're not testifying.
Okay.
Sir, please stand.
Oh.
You're arguing now. You're not testifying.
If she would like to talk to Concord at the school, I'm 100% okay with that. I see no issues with it. The one issue I had about him going to counseling, like I said, with my oldest son, he went to counseling. He thought she became the problem. He became suicidal after that. That was my biggest issue with him going to counseling. And you want her to take it serious. So, two or three messages, I don't find that taking it serious or pushing for him to go from. And as far as anything else goes, I see there has been no evidence of intimate harm or danger to seek in our household that has been provided to the court. So I don't see within anything having changed would be necessary, but I am okay with them seeking counseling through the school if that is necessary, and they deem it and go see a counselor after that, I would be okay with that.
Your Honor, I would ask the court to not allow just this school counselor, because one, my client hasn't agreed to doing that. That's the first time this has ever been brought up, and it's a little bit frustrating when we've gone through a hearing. We were here before, now we're here again after the motion's been filed, and now he's telling the court, well, I'm okay with this other counselor. He could have done that months ago. He could have done that, 6-8 months ago, but yet here we are, and he's telling the court that now. I would ask the court that to not consider that at this point and allow the child to be enrolled in counseling that the parties either agree to or that the court is potentially required to select.
This is a motion regarding changing the legal custody of this matter filed by the plaintiff. There must be a showing of either proper cause or change in circumstance based upon the preponderance of the evidence to have this matter move forward relative to issues of legal custody. Because if there is proper cause or change in circumstance, then at that point in time, the court can look to the best interest factors after determining if there is an established custodial environment and with whom. The testimony presented in this case included information at the previous hearing regarding the child being ill at defendant's residence, vomiting in bed that evening, and not reporting. This was the initial part of this, as well as this issue relative to counseling. Today, we've had additional testimony provided by mother specifically regarding the alleged behaviors of the minor child, that essentially the child is off, doesn't know, doesn't cuddle anymore or less, and that mom really wants to make sure the child has an outlet to open up and to share information if there's something bothering the child. And the testimony that I heard, it appeared to the court that the child just wouldn't talk or wouldn't open up or wouldn't engage with mother. Now, yesterday I had the opportunity to meet with C, a complete stranger, 7 years old, going on 8. And I smile as I talk about this child, because this child wasn't afraid to speak. This child opened right up, and how it's done, without going into great detail, is we let the child know right out of the gate. And we do this in every case. My chambers, there are 4 walls. It doesn't go outside the 4 walls. You share with me anything you want to share with me. If you don't understand a question, we'll rephrase it. We open up and let the child have an opportunity to speak. And this child didn't hold back. He let it out there, and I'm not going to disclose what the child said, but I can tell you that I didn't hear anything regarding anything negative of anyone. Anyone. I'm talking parents, step-parents, other siblings, significant others, none of that. And this child was not afraid to sit down with 2 complete strangers and share this. Mom's alleging that the child is not opening up to her, whom mom has had since birth. And she further testified that around 15 minutes or so, then he kind of gets back to normal. And everything is fine. He wasn't engaging initially with the other people in the home. Well, I'm not a counselor. I'm not a therapist. I have family that does that. But I'm not a professional. I can't sit back here and say, this child needs this or this child doesn't need this. Again, I go back to the child wasn't afraid to share anything with this court. And that's one side of it. But on the other hand, I don't know, are there other triggers or other signs or anything else that would indicate that the child may need counseling? Well, regarding the counseling at this point, and the legal custody aspect of this, again, there must be a showing of proper cause or change in circumstance. Change of circumstance since the entry of the last order, you have to look at something more than a normal life change, something evidence that material changes have had or will have an effect on the child, and the facts are gauged by the best interest factors. And I just do not see a change in circumstance based upon everything I've heard, nor do I see proper cause. As a result, the motion regarding legal custody is respectfully denied. However, regarding the counseling aspect of this court is intimately familiar with the Bad Axe Public Schools and their counselors, at least as of a number of years ago. And Mr. Curvin, apparently he is still there as a counselor and is there 3 times a week. Now, the general idea of this is when it comes to legal custody, if the parties cannot agree, then it's up to a court to make that decision, and potentially one party could lose legal custody. Again, I'm not a counselor or therapist. I don't know what it takes to say, hey, you need to speak to someone. Mom says the child does. Dad says doesn't appear the child does. That needs counseling. Again, when I spoke with the child, completely open. I mean, not afraid to share anything. However, I agree with Mr. Majeski relative to Mr. Curvin speaking with this child. Mr. Curvin has had experience in this courtroom as well. He's been here before. And if, after speaking with Mr. Curvin, that Mr. Curvin believes there are issues, those issues should be shared with the parents. And frankly speaking, accepting Mr. Majeski's words, if Mr. Curvin thinks there's assistance that needs to be provided, then it should be provided. Simply put. Now, I understand on the flip side, hey, look, I took another child to counseling and these issues happen. I understand that as well. But really it comes down to, in this case, the inability of these parties to communicate. And what I mean by that is if, for instance, one parent says, hey, I think this child needs this. And then parent B says, well, I don't think so. There has to be communication between the two of you regarding why this should happen or why it shouldn't happen. It shouldn't just end with okay or no or well, I think we should. Well, why should we? What I heard today is that the child doesn't open up, yet the child opened up with the court. The child doesn't, it takes about 15 minutes. Court can take judicial notice of every other file that the court has had relative to custody and parenting time. I cannot remember a single case where a parent would say, well, when they come back from dad's house, the child's different. It happens all the time. It truly does. It takes, you have to go back from that week you were with one parent and then adjust back to the other parent and back and forth. But there's nothing I heard that just jumps out at me and says, we have to do this or we don't have to do this. I believe both parents. I believe both parents, and that's why the preponderance of the evidence standard has not been established. However, I will require, and Mr. Jean, if you place this in the order, that the child is to meet with Mr. Kervin and based upon Mr. Kervin's recommendations, if something is needed, both parents better be able to sit down and discuss it and move forward with it. And again, Mr. Majeski stated under oath, if Mr. Kervin or any other individual at the school says, therapist that is, says, you know what, I think the child needs it, and the child should be going to